Be ready. Start. After careful perusal of the aforesaid decisions, we have no scintilla of doubt that the view expressed, which has a base of commonality, is absolutely correct, and there is no necessity to dwell upon the same, more so when there is no cavil or conflict in this regard, and there has been no reference on the said score. Additionally, no doubt has been expressed relating to the exposition of the said view, and irrefragably correctly so. The demonstrable facet of the discord is that if cognizance is directly taken by the special judge under the act and an accused without assailing the same at the inception, allows the trial to continue and invites a judgment of conviction, would he be permitted in law to question the same and seek quashment of the conviction on the bedrock that the trial judge had no jurisdiction or authority to take cognizance without the case being committed to it, and thereby violated the mandate enshrined under section 193 of the code? To make the maze clear, it is profitable to note that in Gangula Ashok Supra, the appellants had called in question the legal substantiality of the order passed by the single judge of the High Court of Andhra Pradesh, who, after expressing the view that the special judge had no jurisdiction to take cognizance of the offence under the Act without the case being committed to it, set aside the proceedings of the special court and further directed the charge sheet and the connected papers to be returned to the police officer concerned, who in turn was required to present the same before the judicial magistrate of first class for the purpose of committal to the special court. That apart, the single judge further directed that on such committal the special court shall frame appropriate charges in the light of the observation made in the order. The two judge bench accepted the view as far as it pertained to setting aside of the impugned order, but did not approve the direction issued for the steps to be taken by the special judge for framing of charges, as it was of the view that no direction could have been issued to the special court, as it was open to the appellants therein to raise all their contentions at the stage of framing of charge if they wished to advance a plea for discharge. Thus, it is evident that the accused appellants had challenged the order of framing of charge and sought quashing of the same before the High Court. They did not wait for the trial to commence and the judgment of conviction to visit them. After the dictum in Gangula Ashok Supra, the High Court of Madhya Pradesh was dealing with an appeal, Bhuraji Supra, wherein the appellants were convicted under sections 148, 323, 302 stroke 149 IPC and sentenced to various punishments, including imprisonment for life. It is worth noting that they were tried by the special judge under the Act, as a charge sheet was filed under section 3, 2 of the Act along with other offences of the IPC. When the matter came up before the division bench of the High Court, the learned judges commenced the judgment with the prelude that the case had sluggished for more than 9 years, and the end was not in sight, as direction for retrial seemed inevitable because of the decision rendered by this court in Gangula Ashok Supra. Be it noted, cognizance was taken directly by the special judge in the said case also. The anguish and the helplessness expressed by the High Court was taken note of when the state of Madhya Pradesh approached this court. This court laid emphasis on the fact that it was a case where the accused neither raised any objection when they were heard at the time of framing of the charge, nor did they raise such a plea at any stage either before or after the evidence was recorded by the trial court, but a significant one proponed such a contention only after the conviction was recorded, and that too after the decision in Gangula Ashok Supra was rendered. As is perceptible, the bench posed the question whether the High Court necessarily should have caused the trial proceedings to be repeated only on account of the declaration of the legal position made by this court concerning the procedural aspect about the cases involving the offences under the Act. The bench referred to the provisions contained in sections 462 and 465 of the code and adverted to the concept of a failure of justice. It is an uphill task for the accused in this case. Thank you.